Namaste and good morning, distinguished colleagues and esteemed guests. I, Aditya Giri, advocate on record and member executive of the Supreme Court Advocates on Record Association, on behalf of the entire executive committee, welcome you all today as we gather for the fifth and this year's final lecture in the Scaora lecture series. And I am privileged to welcome a truly exceptional legal luminary, Dr. Abhishek Singhvi, Senior Advocate and Member of Parliament. Dr. Singhvi represents the rare confluence of political acumen and legal brilliance. Those who have witnessed him courtroom performance can attest to his extraordinary skill, his ability to navigate the most complex legal landscapes with remarkable dexterity and intellectual finesse. I have personally observed his remarkable talent for transforming intricate legal challenges into compelling arguments with an almost spellbound perfection. We are fortunate to have him address a topic of profound contemporary significance, the 10th schedule of the Indian Constitution, more commonly known as the Anti-Defection Law. Introduced in 1985 through the 52nd Constitutional Amendment, this provision marks a pivotal moment in our constitutional history. The amendment was a strategic response to the endemic problem of political defections, designed to bring stability to our legislative institution and safeguard the fundamental principles of electoral representation. Before we delve into a nuanced exploration of whether this law represents a necessary regulatory mechanism or an unintended constraint on democratic expression, I invite Mr. Nikhil Jain, Secretary of the Scaora, to introduce a gentleman whose contributions to law and politics require no formal introduction. Nikhil, sir, please.
Good morning, everyone. Our esteemed speaker for today, Dr. Abhishek Singhvi, Senior Advocate and Member of Parliament, is a trailblazer in the legal profession. He holds the unique distinction on being the youngest lawyer to be designated as a senior advocate. His accolades include the Global Leader of Tomorrow award by the World Economic Forum and a doctoral degree from Trinity College scholarship for PhD. His eminence as a jurist and politician is unparalleled. In addition to being a four-term member of parliament, Sir has also chaired parliamentary standing committees on commerce, on law, and on home affairs. He is a member of the Congress Working Committee, Congress Supreme Decision-Making Body, and a top senior counsel in the Supreme Court of India. He has been an additional Solicitor General of India. Besides his extraordinary juristic skills, he is a distinguished author and a well-known media face and a commentator on diverse issues. Carrying forward the legacy of his father, Dr. L.M. Singhvi, Sir has tendered his devotion through his robust knowledge to nurturing the legal profession. He has worked painstakingly to uphold its imperiality. Sir's multifaceted and versatile personality straddles public life, media, law, and academia. Knowing as the ultimate multitasker, he manages these diverse areas with excellence, commitment, and sincerity, and is rated amongst the top in each. Today, his numerous columns in Hindustan Times, Times of India, and other dailies have been published as two books titled Candid Corner and Straight Talk, both with forewords written by Dr. Manmohan Singh. His last book, From the Trenches, selects 8 judgments he argued that have impacted the nation and tries to tell the story behind each. He is also an occasional columnist in major Hindu dailies, Dainik Bhaskar, Rajasthan Patrika, Indian Express, and its sister Jansatta. Author of innumerable articles on a wide diversity of non-legal and legal topics in several leading newspapers and technical journals. Singhvi's definite 1.5 world legal analysis of the law of emergency powers in a comparative common law perspective was also jointly released by the CJI and other 3 honorable judges in January 2021. Dr. Singhvi has been a key figure in almost all landmark Supreme Court cases over the last 4 decades, spanning constitutional law, corporate law, arbitration, among other subjects. His role as the amicus in the landmark judgment of D.K. Basu versus State of West Bengal is a testament to his commitment to justice for all. Beyond his extraordinary legal journey, Dr. Singhvi's outreach and humanitarian endeavors are commendable. He supports many charities with significant contributions, including a standalone prayas Center for Destitute Children, the Singhvi Scholarship at the Trinity College, Cambridge, and various medical assistance initiatives. His contributions to the Supreme Court Bar and other charitable institutions are substantial. The Singhvi Endowment, created by him in mid 2022 at Jindal Global University, offers multiple benefits to meritorious male and female students, a memorial lecture, a global multidisciplinary seminar, and so on. Over the years, his personal donations have aggregated a very large sum of money. Without further ado, I would like to invite Dr. Singhvi to kindly give today's lecture on the 10th schedule, Unnecessary Evil. Sir, please.
President Vipin Nair, Vice President, each and every esteemed member of the Executive Committee. I will not name you all individually. Those on the screen, I can see, of course, Astha Sharma, Aditya, Mr. Nikhil Jain, my friends there. But each one of you, members of our tribe, members of our community, members of our profession, it's truly an honor, a pleasure, and a privilege. And thanks for a very, very generous and kind introduction. You know, monopolies are generally frowned upon, as all of us have learned in law. But you, each one of you of this association, represent a very special, exclusive monopoly. You are an elite club of those who alone can file in the Supreme Court. It's a special subclass monopoly within the larger monopoly of persons known as advocates who alone can address the court. But you are truly an exclusive club. And it's therefore a privilege and a pleasure to be able to accede to your request to address this gathering virtually. Friends, I could lecture on law, on theory, on constitutional text, on case law. But the topic I've chosen, if I do that, would be very pedantic. In fact, in this case, it would be almost unreal. Many, many moons ago, as a young lad of 30, in 1989, I had an occasion to be the chief election agent when my father was asked at short notice, at 15 days' notice, to fight a Lok Sabha election from Pali. That, by the way, was the year when the party for whom he fought lost all 25 Lok Sabha seats of Rajasthan. But as chief election agent, and as you know, under the law, the chief election agent is really deemed and designated in law to be the alter ego of the candidate. After that, as a young man, having experienced the grassroots in a western, spread out rural area of Pali in western Rajasthan, I wrote an article in the then Illustrated Weekly of India, which used to be a major magazine in those days, called Elections, Law and Reality. And the only solace my father got after his defeat in the Lok Sabha was a very nice letter from Justice Krishna Iyer saying, well, I sympathize with you, LM. You lost the election, but at least it gave the opportunity to your son to write a wonderful article. Now, the reason I say this is because that was about law and reality. And that's pretty much what I'm going to talk about today on defections. The theory and the law on one side and the reality on the other. Because this is more about what they don't teach you at Harvard Law School rather than what you find in the bare text of the schedule or of the case law. Well, we have a provocative title, A Necessary Evil question mark. Deliberately provocative, but also misleading. Because I am now, after many decades of legal practice and appearance in almost all the major cases on this particular subject, but more importantly, in my role in public life, I am now of the firm conviction that it is A, an evil, and B, not necessary to have the 10th schedule at all. So that's the conclusion I have given you upfront. And therefore, it should be dropped. The 10th schedule should be dropped, except that it should be replaced with a one-line or a two-line 10th schedule. If we want to be honest to ourselves and to our consciences if we want to be genuinely eliminating what we call, and what 10 judgments of the Supreme Court have called, quote unquote, a constitutional sin. The two lines with which I would replace this entire fasciculus of provisions in the 10th schedule would read thus, quote, any person who defects must resign and shall not directly or indirectly occupy either legislative or ministerial position without being re-elected to the lower or upper house. Unquote. So simple, clear, straightforward. No intellectual nuances, no verbal nuances, and no intellectual acrobatics, no immoral histrionics. And let me give you example after example in this address, and you judge for yourself the usefulness regarding the continuance or otherwise of the 10th schedule and the jurisprudence which we spawn around it. Is it worth the waste of time? Does it have preaching, a lot of preaching without practice? Ayalal and Gayalal happened when there was no 10th schedule. But much, much more than Ayalal, Gayalal have happened after the 10th schedule. And I always say that Ayalal would blush if he saw the operational reality of the political system under the 10th schedule. The reason for that, friends, is that the great Indian Jugaad, there is no equivalent for it globally. The great Indian Jugaad, our remarkable genius for distortion of the most sophisticated scheme, has overtaken the 10th schedule, which is why I said, let's scrap it and let's have a simple rule that the moment you want to change colors, you must fight again. Now, let me give you some very interesting, startling examples. You have the 10th schedule, the text is not so important as how it operates in reality, which is the thrust of my interaction with you today. And I'll just give you in point form various different facets, which you may have noticed, which you may have seen in passing, but which you may not have looked at in detail. So the first of those is the aspect of delay. So I'm the complainant, Vipin Nair has defected, and Ms. Asta sitting here is a speaker. The simplest way to deal with the subject and make the 10th schedule a nullity, as has happened in innumerable actual cases, is for Ms. Asta as the speaker, so long as she belongs to the party other than that of the complainant, to simply decide not to decide. She decides not to decide the complaint of Mr. Singhvi about the defection of Mr. Nair. And the process of deciding not to decide can extend up to 3 years, 2 years, changing the complete political landscape, the underlying reality, and making the real live event of defection infructuous or irrelevant. It is this which led an anguished Justice Nariman in the Manipur case, where the delay by the Manipur speaker was egregious. I think it bordered close to 3 years or just under 3 years. And that was after at least 3 directions of the Supreme Court saying decide in 2 months, 3 months, etc., etc. Whereupon a judicial detailed judgment, a seminal and a very landmark judgment, the so-called Manipur judgment, the Supreme Court held that, look, if you do not decide with this final verdict of 3 months, then it shall be deemed that the person against whom the allegation of defection has been made is deemed to have vacated his seat without your decision. That's the kind of walk the talk we need. But does it happen? No. I have myself done cases, and one remarkable example comes from Tamil Nadu, where the speaker decides not to decide. I'm talking of older cases, pre-Manipur. The speaker decides not to decide, 3 months, 4 months, 6 months pass. The complainant then goes in desperation to the High Court. The High Court passes a detailed order saying this is wrong, but we have no power to direct the speaker. We hope and trust that the speaker will decide soon. The writ is either kept in pending or the writ is withdrawn. The man makes a second representation to the speaker. The speaker takes another 6 months. The man goes again in the High Court. The High Court says, look, we don't have power to give directions to the speaker. That complainant goes against that order of the High Court to the Supreme Court. The Supreme Court is bolder and gives a direction, decide, but doesn't fix time limits. Manipur came later, Justice Nariman came later. The speaker again takes another 6 months. I have done this footballing actually in a case which has consumed 2.5 years. Speaker, High Court, Supreme Court, back to High Court, back to Speaker. Ultimate object is that the fruits and the benefit of defection are fully and completely absorbed by the time any vestige of justice comes. The second aspect, and remember, all these aspects show that this is now a mockery. It should be repealed and replaced by a simple principle. Of course, when I say repeal means there should be a 10th schedule, but with a simple one-line mandate. I don't say there should be nothing against defections. You must make it very clear, if you really consider it to be a constitutional sin, that anybody who intends or does change his political colors must fight elections again, be it of the upper house or of the lower house. The second facet is this misconception. The misconception of a 1/3, 2/3. As you know, the 1/3 we did away with a long time ago. That 1/3 will go here and all that was repealed some time ago. But the misconception today prevails that if 66% out of the legislature party leave, then there is no 10th schedule and no defection. That is completely wrong. It is completely wrong because the requirement, if you pick up the 10th schedule and read it, I will not be pedantic, I will not read it here, is that there must be a departure of more than 2/3 coupled cumulatively, I repeat, coupled cumulatively with the merger of that group with another political party. So unless one party substantially above 66% merges with another party, defection law applies, 10th schedule applies. A fact frequently forgotten. A fact in common parlance and understanding assumed to validate just a 2/3 departure. No, there must be the creation or rather the merger with an existing political party. Of course, in a lighter vein, this 2/3, 1/3 business led a person to comment, a wisecrack to say, quite rightly. He said, therefore, defection law prohibits, retail trading of politicians, but encourages wholesale trading. If you do a retail departure, then you are stigmatized. But if you do wholesale departure, you will have a validation, which is another strange aspect of this law. Number 3, of course, now all the cases have decided, there are any number of cases, and you know them, most of them, which have decided that the concept of defection, which is the voluntarily giving up of a party membership or of a party, can have myriad forms, shades, colors. It can be explicit, which is the simplest. I hereby leave the Congress and join the so-and-so. Or I hereby leave the BJP and join the so-and-so. That is obviously not the way defections are done because nobody is foolish enough to do that. They all rely on various Indian jugaad and lawyers. So they say, the law also now says, apart from the explicit, there are several implicit ways, and they are in fact itemized in case law. Abstention to a whip. Please must come and vote and you abstain. Not voting, voting against, going in a busload of the rival party to the governor and standing there and making a representation against your own party. Speaking in a particular way in a grouping which is intending to topple the ruling party or their own party. and standing with them. So all implied forms are also and rightly held to be a voluntary giving up. But they are now held up in very interesting jugad imbroglios. Let me give you two out of many more examples I'm going to give you. One is this notice period. Most assemblies require a 14-day notice by a complainant to the other group which is alleged to have defected, which must lapse before the speaker can start acting on the complaint. Some assemblies have 7 or 10 days. Each assembly has its own rules, but I'm giving you an average kind of a paradigm. However, in some important judgments coming from Karnataka, especially Yedurappa's and Nayak's judgment, it has been held that in specific exigencies, even 5 and in one case 3 days notice was upheld as sufficient notice, despite the rules providing for 10 or 14 days. But this notice period, even the shortened one, sometimes operates very weirdly, because the whole object is that the procedural part of notice should not eat up and gobble up the larger necessity to prevent the defectors from getting the fruits of their defection. That's the larger object. You cannot make procedure override the substance. And by a pedantic, puerile insistence on the notice period, you in fact allow the defectors to get the full fruits of their defection. A stark, interesting example of this happened recently in Himachal. Now, I say this in a lecture as a lawyer, but it also happens that I was a victim of that particular incident. But therefore, you must credit me with special, greater knowledge and experience. But I don't say it for that reason. I say it because it is a very good learning process. In Himachal, the defections were very clear, 9 of them. Because in a Rajya Sabha voting, as you know, you have to go and show your vote before you vote. So before I vote for you or against you, I must show your vote, show my vote to a person designated who stands there. So you know that you are voting against so-and-so. 9 voted. Now, foolishly, the ruling party there was having a budget session at the same time. Normally, during a Rajya Sabha election where there is some chance of this cross-voting, I don't think anybody should be foolish enough to have a budget session. Because suppose I go and I vote against Astha, who's standing for Rajya Sabha, and then after voting against her, who belongs to my own party, I then go down, just the elections are normally held in the assembly, and go into the house and vote as the party on any money bill, the whole government can fall. Because a budget session has number of money bills, and it's a dangerous time. So normally it should not have been held there, but in Himachal, the budget session was ongoing parallel with the elections to Rajya Sabha. So the same evening, by which time it became clear that 9 had voted against the official Congress candidate, that is myself. After everything was over, and I was on my way back the next day to Delhi from Shimla, the speaker, who was an interesting character, sat with me and said, "Look, what is to be done? We have to give notice of so many days. And there is a very dangerous situation, because if I give notice, and understand this, if I give notice, after receiving notice, the other person goes down the next day and votes. The government topples, the fruits of defection are there, everything changes, and then the defection is irrelevant." So I told him, first of all, that anyway, your rule of 14 days is not really relevant, because there is this case law and that case law. There is Yedurappa and Nayak and other judgments which allow a 3-day notice, which is the minimum which I have heard till now. But even 3 days can be fatal, because 1 day can give the defectors the chance to take benefit of their defections. So I told the speaker, who's quite an interesting character, an ex-lawyer, but a very bold chap. So I said, look, you can send them a letter saying that there is no need to give you more than this overnight notice and call them tomorrow, because what is there to give notice about? We have all seen you showing the vote. So I'm giving you notice, come and tell me anything you want tomorrow morning, which is less than 12 odd hours. The speaker did that on my advice. I left for Delhi. Next day they came. He heard them. He said, there's nothing to hear, because You tell me what you want to tell me. Please explain why you voted against the candidate. This is your showing of the vote. And he disqualified them. Now, in this case, therefore, I'm not talking politics, by the way, I'm talking law. A notice doctrine appropriately applied saved the government of Himachal. Be very clear. 9 defectors in a small assembly is a large number. Himachal is a very small assembly. The government would have fallen had a pedantic approach to notice of even 2 days been followed. The assembly was on that day, on the day they were disqualified. Because of that, the government survived. And of course, the footnote to this is that those who were held defected by an interim order of the Speaker challenged in the Supreme Court. Ironically, I appeared against them, and their petition was dismissed, and the Supreme Court gave no interim order to them. And then ultimately things happened. Then another fascinating jugaad concept in India, how we have destroyed the spirit of the 10th schedule. There is a judgment called Nebia. What is it? Navam Rebia. It's a constitutional bench. It arose on a totally different issue. Arunachal Speaker and governor and other things. I won't go into that now. Now, in the course of that judgment, out of being a little more kind of large-hearted and speaking a little more than was necessary, I call it obiter actually, Justice Keher put a paragraph. The paragraph said that, look, there may be cases, and he was trying to be very extraordinarily fair and objective, and something which didn't really arise in that case directly. What happens where A makes an allegation of defection against B to the Speaker C? But before that, there is already from A's group or A's party a complaint of lack of confidence or no confidence pending against the Speaker. Then how can the Speaker be the persona designata to decide the 10th schedule? Which, by the way, is a complete obiter, didn't really arise. And in any case, the Constitution 10th schedule makes a sole person the persona designata. You cannot have a deputy speaker doing what the 10th schedule, there's no provision. You can't have the President of India or the Vice President of the Prime Minister doing what the 10th schedule says the Speaker must do. There is a sole persona designata. Excuse me. So Justice Keher then said that in that case, this complaint of defection to the Speaker must be kept pending and in abeyance till the no confidence against the Speaker is decided. Now, this has been so grossly misused, and let me give you the operational example of Maharashtra, where it was misused. In the Maharashtra Shiva Sena, BJP, NCP case, and this is exactly this, I'm not talking politics, I'm talking facts and law. These are the sequence of dates. On day 1, a group of people get together and decide to break the government of Uddhav Thackeray. So they go and meet at various places. On day 2, they travel out of Bombay in various resorts. Some go to the northeast, etc. But before day 1, on day 0, they file a no confidence complaint against the Speaker. This is what I call Indian Jugaad. Because some bright lawyer has read Navam Rebia and he's given them that paragraph. So before departing for the resorts in Northeast, they file a complaint. And then when the matter comes to Supreme Court, I happen to appear on a vacation June hearing, late evening, before a bench. The principal argument on the other side is, look, till such time as this no confidence is decided, the Speaker cannot decide our complaints. So the Speaker is disabled. Why? Because here the defectors were against the ruling party and the Speaker belonged to the ruling party. So unless they disabled the Speaker, he would have passed an order. Unfortunately, the Supreme Court at that time, based on the Navam Rebia governing principles, by the way, Navam Rebia has been specifically referred to a larger bench, specifically, and doubted while being referred. And that imbroglio should be clearer at the earliest. But in that case, in the Maharashtra case, the interim order of the court disabled the Speaker from deciding. And therefore, you find here actually the insulation of defectors from the wrath of the anti-defection law. And the result is that you are able to enjoy the fruits of your defection. till such time as some time passes, by which a lot of things change. My fifth point is about the very concept of a speaker. By speaker, I include the chair of the other house always. This whole thing is flawed because ultimately it's unreal for all of us to give lectures and to imagine that a speaker belonging to a political party which elects him speaker is going to rule against his party. This is the fundamental flaw of the 10th schedule as it exists. We have noble principles in our mind. We have high-sounding declarations and rhetoric, but we must realize that human nature is much bigger than all this. So it's no point expecting that just like any other MP or MLA elected on a party ticket, who is subsequent to election chosen as a speaker, he will, as Mavlankar put it, have no ears and eyes and will leave his party affiliation by a magical wand. It doesn't happen like that in practice. And that is the nub of the lack or the absence of an independent, objective, adjudicative authority. So what do? The 10th schedule is only the speaker. The only way out, according to me, if you want to keep the 10th schedule, which I'm not in favor of at all, except with my one-line, two-line amendment, is to do what in olden times, for some time, British used to do. They used to decide in advance, all the parties by consensus, that XYZ, a statesman-like figure, figure with a certain stature in society, shall be the speaker. And then, pre-elections, that person, woman or man, is put up as a speaker and virtually elected unopposed or with very little opposition. That person is therefore freed from party affiliations. Otherwise, it's idle rhetoric to say that the speaker will rise above party affiliations. And unless that is done, this 10th schedule will continue to remain. Unless that reform in the speaker's office is done, unless that reform in terms of the speaker's concept is done, then this will remain idle rhetoric. Then the seventh facet, another new Indian jugaad, is stratagem, which completely turns the 10th schedule on its head. Now, this is a little complicated, so you'll give me 2 minutes on this. Group A is defecting. They know that they'll be hit by the defection law and they'll lose their seats. So, and this happened exactly the way I'm saying it in Maharashtra case. Prior to defection, they file a complaint before the Election Commission under the symbols order, saying that this group, the defecting group, should get the symbol of the party from which they're defecting. Now, it is common ground between all parties that the Election Commission has no locus and no jurisdiction to decide defection. That's only 10th schedule, that's only speaker. And now the Maharashtra judgment has so held categorically. But what the Election Commission does is a parallel proceeding, which is very interesting, which exactly happened in the Maharashtra case. The Election Commission, on a prior complaint before even I defect, takes the complaint, hears the matter, and applies the legislative majority test and not the organizational party test, saying that in the legislature, the total number of MPs 100, so many have defected. They count the defectors as also alleged defectors because the speaker has not ruled till then. On this basis, the vast majority is of the defector group. So sorry if I sound complicated, but if there are a total number of 100 people and let's say 40 have defected and are with another group, party B, which has already got 70. So the Election Commission starts saying that these 40, along with the other party, really are the rightful claimants of the symbol. This is happening under Article Clause 15 of a symbols order, which, by the way, is not even statutory. A symbols order is not even statutory, not even delegated legislation. It is just an executive order by the Election Commission. And after a lot of hearing, the Election Commission grants them the symbol, recognizing that grouping as the main party, counting what? Counting the legislative strength only. So in the legislature, that total party, let us say party X, has 100 people, or let's say not 100, but let's say 10 people, and say 4, 5, or 6 have gone. 6 have gone. So they say in this 6, we count this as the test, but they ignore that the vast organizational party outside the legislature is still with the original party. Anyway, you get the symbol. The getting of the symbol is in fact saying that the real party is the one which has got the symbol. In which case the speaker then proceeds to decide that that is the real party, there is no defection. So you are turning it on its head. Now, this is after the Maharashtra judgment of the Supreme Court has categorically held that the two are apart and the Election Commission cannot apply, I repeat, cannot apply the legislative party test. Because worst adding insult to injury, in the legislative party test, the Election Commission is counting the defectors as part of the legislature, whereas the defection complaint is pending against them. But yet, all this is forgotten and symbol orders are being passed by the Election Commission. I myself argued the NCP case where it happened. And people forget in all this one other important fact. Suppose A defects today, and the time it takes 3 months to decide that he has defected, the Speaker after 3 months holds that he has defected. Or the Supreme Court holds after 4 years that he has defected. 4 years. The law is very clear. The judgment of the Supreme Court holding that Group A has defected will relate back. So they are deemed to have defected on the date when the complaint was made of defection. Now imagine, just because the delays that happens late, by that time the symbol is allotted, the real parties recognizes that, and the fruits of defection are fully enjoyed. The relating back doctrine is completely forgotten both by the Election Commission and by many courts. So the legislative test is per se wrong because the legislative test includes the defectors whom you can't count, and it ignores the lakhs and millions of workers, the organizational party list, which is much more in majority and which is not supporting the defectors. Then, of course, there are other loopholes where to diminish the size of the house, sometimes you diminish the size of the house, then the majority mark becomes easy. So, house of 100, if 20 abstain or resign, then the house becomes 80. Then it only get 40 or 41. So now what is happening is also that by a 41, you are able to topple the government by 20 defectors abstaining or resigning from the house, even resigning. Now, resigning may seem all right to you because you'll say, so what? They defected, but they resigned and they lost their seat. No. Immediately when the government topples because of 41 out of 80, the next day, many of those who have resigned become ministers in the new government. I hope I'm clear. And they become ministers because you have a clause in the constitution that says you can be a minister without being elected a member of either house for 6 months. That's the promise made to them to make them abstain or resign. The next, ninth facet, the judgment of the Supreme Court in the Shiva Sena case is a good judgment, a bold judgment, but only the first 4/5. The last 1/5 is the worst example of operation successful, patient dies. The judgment categorically holds that there was defection. The floor test should have been taken. The legislative majority, there was an illegal defection under the tension. Clear finding. But then it says that after the date of defection, parties were again asked to take the floor test. And merely because Uddhav Thackeray chose not to take the floor test, therefore we will not give him relief. Now here the error is in law, there is no connection between a finding of defection and a necessity to take a floor test. If you have defected, you have defected, you are disqualified, you are out. Those numbers can't be counted. After a finding on that, the Supreme Court adds at the end that we will not disturb the result, we will not remove anyone because the person refused to take the floor test. But well, it's up to him. The defection relates back. Once the Supreme Court gives a finding that there is a defection, it relates back to the date of defection, which means all those people had to be removed. That government, because of this very strange, weird, I would say, finding, not only has Operation Successful Patient died, but that government continued, whereas it has been certified by the Supreme Court to be involving defections. What happened to the doctrine of relating back? Well, I am coming to the end in about 5 minutes. I think it's important that we realize that the reality of this country is that public, I don't like the word politics anyway, so public life figures oscillate so much that a pendulum would be embarrassed. Gayalal did it as an extraordinary case. If you remember 1967, he did 4 hops on the same day. He went from the Congress to the Janata Party, then back to the Congress, and again to the Janata Party, and then finally came back to the Congress same day. So when he came back, Rao Birendra Singh was the man in charge, and he got up and said, now Gaya Lal has become, Gaya Ram, his name was, has become Aya Ram. And that's how this phrase happened. But that is nothing compared to this, of course, extreme example of four times in a day, which is what made this whole thing famous. And that's what brought in the 10th schedule in 1984. But today, in actual fact, the jugards being adopted to evade, avoid, distort, circumvent, and nullify the 10th schedule are far, far ahead. As I always say, it would make Gaya Lal or Gaya Ram blush. He could never think of these jugards. There is now a word my colleague has coined. He keeps looking for new words in the dictionary, Shashi Tharoor. So he has found a new word. He says snollycoster. Snollycoster is defined as a shrewd but unprincipled politician. It's an actual word in the dictionary. But ultimately, friends, it is no point all of us blaming politicians. Remember, we have a similar system to so many countries. Why does not defection happen in England? Why? Ask yourself that question. It's not a very different system. Why does it not happen in several other parliamentary democracies like Australia or New Zealand or Canada? So the real reason is that you and I get the politician we deserve. The politician you get is a reflection of yourself. And unless and until you realize that the finger pointing you do actually is pointing 3 reverse fingers at yourself. So therefore, it's no point just lamenting. Why do you elect and re-elect such persons? If you stop electing and re-electing them, defection will stop. But you elect them, I elect them. And that is why this becomes an empty lament. So at the end, friends, what do we do just? Do we look at the grand rhetoric? Is that rhetoric true? I'll give you one rhetoric. The anti-defection law isn't just a clause in the Constitution. It's a shield protecting the sanctity of democracy and the collective will of the people. Does it sound empty and meaningless? Is it not rhetorical? I'll give another one. Defection undermines democracy. The anti-defection law is a constitutional pledge to guard against such betrayal. Really? I asked myself. Is that what the 10th schedule is doing? Another one, in a democracy, mandate of people is sacrosanct. Schedule 10 ensures that this mandate is not compromised by opportunistic shifts in alliance and allegiance. Well, friends, unfortunately, that's the last thing the 10th schedule will be able to achieve. Last thing. So, as Shakespeare once unfairly said, he said it about lawyers and unfairly. He said, the first thing let's do, let's kill all the lawyers. But I'll adapt that to say fairly and correctly. The first thing to do, let's abolish the 10th schedule and substitute it with a simple principle. The moment you change any political color, you must resign and refight elections. No ifs, no buts, no splits, no formulae. Thank you very much.
Thank you so much, sir. We did had like 4 questions, out of which 2 you have already answered. But I would still like to ask one question, sir. So, question is that do you think that anti-defection law as it stands today infringes on the freedom of legislators to follow their conscience and stand up for their belief or represent the interests of their constituents. Even though you have answered that they should first resign and then they should, go ahead with that. But anything else you would like to add in this?
It's a very important question. Shall I reply?
Please, sir, please. We are waiting. Sir.
Important question, more important than you might imagine. That the application of the anti-defection law is a fetter on free speech. It is a gag order, it's a strangulation. So first of all, in legal terms, it's been answered long ago in that famous Northeastern case, Kehoto Holohan.
Right.
Said the 10th schedule doesn't infringe anything like 19(1)(a) or any of fundamental rights. And it's given a very clear answer. But forget that. What is the premise of your question? The premise of your question is that what is happening in India around you are genuine changes of ideology, genuine changes of conscience, genuine reawakenings of thinking. Well, Aditya, let me ask you, is that really so? Or do I have to get you to wake up and smell the coffee? How many defectors do you know have done it for change of philosophy, ideology, conscience, as you put it?
Right.
So we will be actually living in an unreal world of the ostrich who puts his head in the sand and says, there's no storm around me. I'm very comfortable in this head in the sand.
Right.
Not the reality of India. It is the reality, mind you, in a few other countries. In England, you do have the rare politician. And in America also, which is a much more aggressive system, you do have change. Democrat becoming a Republican. But they are genuine changes of thought, of thinking, of commitment, of ideology, etc. This is certainly not the case in India. And if we continue to think that, we are living in a fool's paradise and we are also making fools of our colleagues.
Very well, sir. Sir, the last question, that should the threshold for disqualification be raised from 1/3 to maybe 2/3 or 3/4?
No, that's the whole point. You already had 1/3, you have 2/3 now, you can make it 4/5, you can make it 9/10. That's all irrelevant.
Right.
What about all the 8, 9, 10 jugaads I gave you? That's the whole purpose of this lecture.
Very well, sir.
These jugaads, you cannot get rid of as long as you have a complicated process like a 10 schedule, which requires lawyers and speakers and politicians to start exercising discretion.
Right.
In my 1-line, 2-line rule, discretion is eliminated.
Absolutely, yes.
You move from this room to that room, you please leave your seat, fight an election again.
Correct.
Otherwise, don't move. Simple. Nobody is preventing you from moving. Your point about conscience and free speech is available. You are so much interested in free speech, go and fight an election again. What's the problem?
Correct. Resign and then go ahead with that.
Yes.
Absolutely. Now, may I invite our President, Mr. Vipin Nair, to say a few words?
So what can one do after hearing such a beautiful exposition of the balance between parliamentary politics and the actual argumentative process in the court? You bridge that whole gap between the two institutions. And today you actually demonstrated the legal acumen and the whole trail, Stephens, Cambridge, Trinity, Harvard, it all came together as a beautiful blend today. It was an absolute masterclass. And you have never raised your voice in the court, but still you got the correct relief because of precisely what you did today. You've convinced most of us. And I think the takeaway from your lecture, sir, was the last part, that why does it happen in India only and not in other jurisdictions, is something we should all think about. With all the elections coming soon, I think that will be a reminder to all. Absolute pleasure, sir. Thank you for honoring us by this lecture.
Well, thank you so much.
Dr. Singhvi, we extend our deepest gratitude for your illuminating discourse on the 10th schedule. Your profound insights have shed light on what many consider a complex and controversial provision of our democratic framework. By characterizing the 10th schedule as a necessary evil, you have demonstrated the nuanced understanding that comes from years of legal and political expertise. Your ability to critically analyze the constitutional mechanism while acknowledging its critical role in maintaining the stability of our parliamentary democracy, sir, is truly remarkable. And sir, your commitment to upholding the principles of our constitution while simultaneously being pragmatic about its implementation is commendable. We are deeply appreciative of your time, your intellectual rigor, and your continued dedication to legal scholarship and public service. Your contribution extends far beyond this discussion, serving as a beacon of constitutional wisdom for current and future generations. Thank you, Dr. Singhvi, for your invaluable insight and continued service to our nation. Thank you all for attending our lecture series this year. On behalf of the Executive Committee of the Supreme Court Advocates on Record Association, we conclude our 2024 program with gratitude and anticipation. We look forward to returning to the new year with an enriching lineup of speakers, continuing our commitment to professional development and knowledge sharing. Thank you so much, everyone. Thank you so much, sir.
Thank you, sir.
Thank you.